Oh no, where's the lighting? Oh, okay. Hi guys, and welcome back to my channel. My name is Amandamoraa, and I keep saying I'm here for the people who want to read a story, just one or two in the newspaper, but they don't want to buy the whole newspaper. Ooh. Yes, and there's a story over here I wanted to read, but time imeshinda tu ikinihepa hivi. But I'll still read it, even if it's not today's, but it is important. So I'm reading from the Daily Nation ya Friday ya October 15th. So si mbali sana. And this is the story. Huduma Card illegal, judge rules. Can you imagine? Me, when I saw that story, I was pissed. Do you know that day I woke up at around 5 ili nikuwe kwa hiyo station at 5:30 so that I don't spend the whole day there, and I was like the 20th person at 5:30. Oh my god, yani hata tu ningelala hiyo siku. Anyway, let me just read this story because kwani voice inapotea. Nimetoka kusoma part 3 of AGNES Tirop story. So if you've not been following that story, there's a part 1, part 2, and then part 3. Haya, tusome ya Huduma Card, which is illegal after all that we went through. These people have. Anyway. Haya. Court says Interior and ICT ministries failed to conduct a data protection impact assessment before rollout. That's why it's considered illegal. Oh. Anyway, this story is by Joseph Wangui. I'll try and be reading who wrote the story because it's important to give credit. It is not my story. The ministries of Interior and ICT are on the spot over the rollout of the Huduma Card before conducting a data protection impact assessment. The High Court yesterday declared that the decision of the government on the 10 billion project, 10 billion, you want to tell me we wasted 10 billion on that project, was illegal and unlawful for being in conflict with the Data Protection Act. Okay. According to Justice Jairus Ngaah, Ngaah, the government should have conducted impact assessment before processing personal data of Kenyans and rolling out the Huduma Card. He said Cabinet Secretaries Joe Musheru, ICT, and Fred Matiang'i, Interior, together with the Attorney General, acted contrary to provisions of Section 31 of the Act. They, in my humble view, have not appreciated the import and the extent of the application of the Data Protection Act with respect to collection and processing of data collected under the National Integrated Identity Management System, NIMS in quotes, said the judge. He was ruling on a petition filed by the Katiba Institute and constitutional law scholar Yash Paul Gai, who argued that it was wrong for the government to roll out the Huduma Cards before conducting a data protection impact assessment. The petitioners premised their argument on Section 31 of the Data Protection Act, in brackets 2019, arguing that the government's move was a threat to the right to privacy. The law says, among other things, that where a processing operation is likely to result in high risk to the rights and freedoms of a data subject by virtue of its nature, scope, context, and purposes, a data controller or data processor shall carry out an assessment of the risks to the rights and freedoms of data subjects. What? Ebu tusome tena tuelewe vizuri. The law says, among other things, that where a processing operation is likely to result in high risk to the rights and freedoms of a data subject, we were the data subjects as a nation, as a people, by virtue of its nature, scope, context, and purposes, a data controller or data processor, which is the government, shall carry out an assessment of the risks to the rights and freedoms of data subjects. In short, wanafaa ku carry out a data protection impact assessment. They know all the risks which are involved. They tell us the risks so that we agree, okay, we can take that risk, and then they continue with the project. But they did not do that. The law also provides that the data impact assessment reports should be submitted 60 days prior to the processing. Justice Nga dismissed the government's argument that the act could not be applied. Justice Nga dismissed the government's argument that the act could not be applied in relation to the Huduma Numba because the data was collected under the NIMS. The government had also argued that the rights of privacy protected under the Constitution were guaranteed, but the judge noted that NIMS was under law, the Miscellaneous Amendment Act number 18 of 2018, which was nullified by a 3-judge bench last year together with 23 other laws. CS Musheru and Matiang'i embarked on a nationwide collection of personal data. In other words, Section 9A, the newly introduced provision of the Law and the Registration of Persons Act, was the legal basis of the nationwide exercise to collect data, said the judge. Lest we forget, the Miscellaneous Act was nullified by a 3-judge bench, among other laws that were purportedly enacted by the National Assembly without involving the Senate, contrary to the Constitution, he stated. Whew. So in short, I don't know. I've never gotten my Huduma card. I've never even gotten an SMS to go pick it. If you have, please let me know. I want to know. I really want to know who has it. I don't even know how it looks. Na sasa tumeambiwa ni illegal. That's taxpayers' money, 10 billion. So I don't know if they're supposed to go back and do the assessment. Ama hivyo tu ndio vitu zinapoteanga Kenya na Wakenya usahau. My God. That day I felt it. Lack of sleep, lack of everything. And then you tell me it's illegal. You know what? Bye. I say bye. See you in my next video. See you in my next story.